Can a revocable trust be changed into an irrevocable trust if need be for Medicaid protection of community spouse in the future? Okay, so there's an important thing to realize about trusts and Medicaid protection. So when somebody is trying to set up Medicaid protection in advance of them needing Medicaid, meaning they want to set things up so if Medicaid's needed in the future, they can qualify. Often what needs to happen in this scenario is the person needs to remove income and assets out of their estate so that they can get their income and their assets to the level that's allowed to qualify for Medicaid. So Medicaid has an income allowance of $2,829 a month. So any income that you're bringing in a month, if it's greater than $2,829, there's an issue there for qualifying for income purposes, and you have to have your assets down to at least one day out of the month. You can show, like, say, $2,000 in your bank account, and that's it. So you have to also significantly reduce your assets. So oftentimes what people will do is, in anticipation of potentially needing to be on Medicaid, they will transfer assets out of their estate so they're no longer considered their assets. This does not occur with a revocable trust. So when you form a revocable trust, nothing is being removed from your estate. Any asset in a revocable trust is very much still under your control, under your ownership, and is still counted as part of your estate. So in order to actually get an asset out of your estate, you would have to transfer it into an irrevocable trust. If it's in an irrevocable trust, again, an irrevocable trust has a different trustee than you, so you're giving up your ownership, essentially your control over the asset. That's what effectively gets it out of your estate for Medicaid purposes. So you would need to transfer these assets above the allowable limit that Medicaid has to an irrevocable trust in order to start setting things up for Medicaid qualification. Now, why is this important? So Medicaid has rules when it comes to gifting, or the gifting of assets. And in Florida, we follow Medicaid guidelines for gifting that says if you give something to a person or to an irrevocable trust to get it out of your estate, you had to have made that gift 5 years before needing Medicaid. So if you end up needing Medicaid 3 years after you make the gift, or 2 years after you make the gift, then there's going to be penalties assessed against you. So we don't want this to happen. So in order to make sure any assets that you transferred are going to steer clear of that 5-year rule, you need to make sure that you start with the irrevocable trust if you're doing this type of planning. Now, this is not the only type of Medicaid planning that can be done. However, if you are choosing to do this to set up a trust in order to move assets out of your estate so that you can qualify for Medicaid, you don't get to use years that assets were in a revocable trust and then make it irrevocable and qualify for Medicaid, because having your assets in a revocable trust, you're not actually getting them out of your estate. You're not gifting them. So that 5-year clock does not start running. It only starts running when the assets are transferred into an irrevocable trust. So although you can start an irrevocable trust or form one after you have a revocable trust, that 5-year clock is only going to start ticking once you move assets into the irrevocable trust. So, things to remember about a revocable trust, it's mainly being formed just for probate avoidance. So it is not going to help you with Medicaid qualification. It's not going to assist with asset protection, but it does have a very important place with making it so that your beneficiaries do not have to go through the probate process, don't have to pay a lot of money and go through a lot of stress and have a lot of time spent in trying to get your assets after you pass away. So those are very important benefits, and those are the benefits of a revocable trust. They don't benefit you so much with asset protection or with Medicaid planning, because those aren't the types of trusts that are used for those things. If you want asset protection or Medicaid planning, you should speak with an elder law attorney or an asset protection attorney specialist in this area to make sure the right trust is set up for you. All right, so I hope this answers your question. If you have any other questions about Medicaid planning, revocable or irrevocable trust, anything to do with estate planning, asset protection, or probate, and you are located in Florida, please don't hesitate to contact our firm at Cause Law Office. The link is in my bio.